What are we going to talk about today? Presumptions, accepting and denied cases. I'm going to talk a little bit about what we should be doing, and then I'm going to try to talk at least half the time about case law example and what not to ever do, because it's terrible and embarrassing and horrifying, and we would never do that here. Just everyone nod, make me feel better. Like, yeah, no, we're professionals. The exemplar that I'm going to go through today is the McGann case. I love this case. It's like just a fun walk in the park. It's got a little bit of everything for everybody in it. So hopefully that'll be an interesting sort of conversation starter. Because I cannot do these practice group trainings anymore with just staring at me, staring me down. Please participate in this presentation. I need it. I can't keep going like this, people. All right. I'm not allowed to day drink anymore. So it's really tough to bring the energy for these things if we're all just like, okay. All right. So what happens? What is our intake department doing here? What are the challenges that are facing our clients? If anybody's following the news, fraud's been in the news a lot, and this is one of our opportunities to sort of battle fraud. So our decision point right at the beginning of the case, and hopefully we're helping our clients reach these decisions. Sometimes they're telling us, hey, we're accepting it or denying it. Let's think through the strategy of accepting or denying a case. Sometimes we're accepting a case, hopefully maybe the claimant's deciding not to get representative. Maybe it's not going to be acrimonious. Maybe it's going to be, we're just going to go down the road. Hopefully they're going to be out of work for a couple of weeks and come back, right? That's 85% of cases. Whether you accept or deny a case, we're losing control of medical immediately. My advice to clients, if you're not certain whether to accept or deny a case, our position should always be deny. Why? If you have a question, deny it, because it's really hard to controvert a case once you've already accepted it, started paying benefits. I've even seen in some judges' decisions, they'll say in there, well, you started paying benefits, so like, now it's re judicata or collateral estoppel against your ability to later say you're denying this case. That's absolutely not true, obviously, right? As our investigation unfolds, hopefully we're learning more information. But in my experience, once we've accepted a case, it's really tough to prevail on a controversy later. I think if there's ever a question, whenever there's doubt, there should be no doubt, deny the case. Gives you a little breathing room. We can conduct an investigation. I'll talk a little bit about how we can cooperate with clients and how clients can help us to get those investigations done. Again, you're not really strategically helping yourself in terms of medical. You never had control over medical. If you just do an investigation and you decide later on, like, oh, maybe this one should have been accepted, well, it's really easy to take a case that's been controverted and then say, I accept it, right? You could do that at the pre-hearing conference, or even as the case is developing, if you're on the expedited trial track or whatever. So just be thoughtful about that. I've never experienced a judge being upset because we controverted a case and then later withdrew the controversy, right? They're pretty happy about that. It's less homework for them to do. They don't have to issue a decision. When we deny a case, our problem, of course, is the timeline immediately begins to work against us. And the timeline on these cases is quite short. All right, so Section 21 is our first barrier or our first challenge. The claimant is afforded a whole pile of presumptions in a workers' compensation case, all found in Section 21. And it's our job, if we're denying or disputing a case, to challenge these presumptions. So let's put these in plain English. The first presumption is that the workers' compensation law applies, that this is a valid workers' compensation case. Again, they file a employee claim form, it's going to be treated as a comp case, even if it isn't. The second presumption that's afforded the claimant is that there is no notice issue, right? We have to raise notice as an affirmative defense. The third presumption they get is the injury was accidental and it was not the result of self-harm. Anyone here ever had a self-harm case? Anyone ever won on one of those? It's really difficult, right? They have to do something that's like outlandish, and really to prevail in an intentional self-harm case, the claimant literally has to write like a suicide note or literally say to someone, haha, look what I'm going to do to myself today. I'm going to jump off the top of this building. Really tough to prevail on those, again, because there's that presumption. The fourth presumption is the intoxication presumption. Even if the claimant is incredibly intoxicated, even if their flipped over vehicle contains balloons full of synthetic urine, because they're obviously trying to beat a drug test, the judge is going to say, well, unless you can prove the intoxication is the sole cause of the accident, we'll consider it a contributing cause, but that's not going to be a strong defense. And the last one is the evidence rule that says anything that's in a medical report is deemed admitted unless you refute it, right? There is no hearsay protection against anything that's in a medical report, right? It's presumed to be true. So these are all problematic from us in terms of defending a case. These are not helpful to us in prevailing. Okay, but we can overcome these presumptions, and they're relatively easy to rebut. To rebut any of these presumptions, the case law says we have to present substantial evidence to the contrary. And then case law goes on to define substantial evidence as essentially any evidence. Now, I know when you are defending a case, what's the thing? Now, this is the part where I'm looking for some group participation. Okay, what is the threat that we get from the judge when we're defending a case and we're denying a case? What do they always say? Frivolous controversy, Mr. Lois. You know, I said, well, Your Honor, I have some contradictory proofs. It could be anything. Even if my contradictory proofs are flimsy, that will overcome that frivolous controversy argument or statement that's made to you by the judge. So substantial evidence in the case law literally means any contrary evidence. It doesn't have to be sustained. It doesn't have to be persuasive. That's a very easy burden for us to meet. So don't concern yourself when you get threatened with a frivolous controversy. All right, the decision point our clients get and we get, employee files a claim, or more typically, they don't go and fill out a claim form. They just start getting medical care. The questions we're going to want to know immediately: are we going to accept? Are we going to deny this case? Are they losing time? How much do we pay in wage replacement? And what happens when there's no supporting medical? Well, we all know under the payer compliance rules, our clients are responsible even if there's no supporting medical for that first 30-day period. So that's a problem as well. All right, 85% of cases are going to be accepted. We never see those cases here, guys. We only see the tiny percentage of cases that are actually disputed, contradicted, and litigated. That's where we live, right? So most cases, most people get injured, lose a couple of weeks of lost time, get some medical, come back to work. Do we have any cases like that? I don't think so. We have a procedure here to help our clients decide whether to accept or deny. And I think it pretty much follows our normal process for referring any other case. But if you're a client and you're listening and you're like, I don't know what to do, should I deny this case? Should I controvert it? What are my next steps? Send us your email. Our intake department will do a conflict check. They will get back to you and give you some advice, and they'll also give you some opinions that you need to, explain maybe to upstairs or your superiors why I'm accepting or denying this case. And if it's a denial, we'll give you the codes that you need to put into your FROI or SHROI. So it's a pretty straightforward process here. If we don't end up opening up a file, there's no charge for that. We do it all the time. We call that pre-litigation guidance, and that all takes place at intake. Now, attorneys, paraprofessionals, you're defending a case, and a client starts asking you questions about another case, right? Or they start asking you, oh, what about this or that, or I have this other situation. I think we all know our best practice here is not to give advice on cases that we're not defending. Flip that email forward or refer that client to intake, let them handle it. Our process here is that even in cases that we don't open up and defend, but that we give pre-litigation advice, we're going to open up a matter inside our system. There's not going to be any billing associated with this because we need to do a conflict check, right? We need to do that conflict check before we're giving anyone any pre-litigation advice. All right, denied cases. And I'm moving through this fast because I want to get to the fun part of this presentation. Our timeline works against us. We decide to deny it. Our client has to file the document, the FROI or SHROI, with the denial codes. If you don't know where to get those codes, contact John in intake. He'll take care of that for you. If there's medical, the courts by law shall set it down for a pre-hearing conference. On average, statistically, that pre-hearing conference is going to happen between 26 and 28 days as after that is filed. So that's going to be pretty quick. We have to then prepare and file our pre-hearing conference statement. We also, our practice here at LOIS is to do a paper C7 as well, unless a client says we don't like those, don't do them. Yes, the C7 is a deprecated form. Yes, we send it anyway because they never amended the statute that says it's required to be filed. So we do that as well. Case is now going to be defended by the LOIS team, our paraprofessionals, putting together what are the right documents, who are the witnesses I need to contact. All of those things are happening pretty quickly. The parts of the denial are really the Freud or Schroy 04. That's the denial type Freud Schroy, and then the pre-hearing conference statement. I can't file Freud's and Schroy's, right? I can't even find anywhere online a good example of a Freud Schroy that doesn't say sample on it. So we can't do that. Our clients have to do it. And when we're defending a case, one of the things we need to do is make sure, did they put all the denial codes on there? Now, we can fix it if they don't do that by making sure that we add those defenses on our pre-hearing conference statement. It's acceptable to do that. Now, every case is going to go on the rocket docket or expedited hearing calendar. And we know from the moment of the pre-hearing conference until the day the judge has to issue a decision, by statute, it's 60 days. So we're going to be on an expedited time frame. Okay, and my advice is be very familiar with Rule 300.38. It's probably going to be about 1/3 to 50% of all of your effort here at Lois Law Firm should be taking place in these denied cases, and particularly at those pre-hearing conferences. So know what can happen there. And I'm going to talk about two aspects of that in a second. All right, skip over this. All right, if we don't file things timely, if our client doesn't file that denial timely, we may be waiving defenses, and then our pre-hearing conference statement as well. What happens if we fail to file the pre-hearing conference statement? Has it ever happened? Yes, right? This is a problem. What happens when we fail to file it? Well, 300.38 F4 says it shall result in a waiver of defenses to the claim, and there can be some legal defenses that you're waiving as well. And section G4, which deals with what happens at the pre-hearing conference, says if we don't give a proffer of evidence for all of the defenses that we're raising, we may be waiving those defenses, and we may be waiving the opportunity to present witnesses in the court or present documents later. And in fact, if our adversaries were very savvy, they would know that if we didn't put in our pre-hearing conference statement, we really can't confront the claimant with it. It really shouldn't be coming into the expedited proceeding. And section G4 of the regulation says that. So the regulation is the rule that governs what happens in the pre-hearing conference. Just my advice is, if you haven't familiarized yourself with section 300.38, it's probably one of the most important sections in the entire rule book. It's really long. Read it, review it. Our best practices on pre-hearing conferences, and I think speaking to the choir here, everybody knows this one. We know that if we fail to file it, it results in waived or limited defenses. That incomplete information is going to be used to limit the proofs. Our practice here is to file a PH 16.2 as early as possible. As soon as our client says we're denying a case, we're preparing that PH 16.2. We're filing it at the time of intake. Is it always complete? No. Is it overbroad and vague? Yeah, a lot of the times, right? Because we're just going to list every possible defense. And when it says list your witnesses, we're going to say any and all potential witnesses, anybody necessary to rebut any statement made by the claimant, any medical witness necessary. We're making it very broad. But then when you're defending the case, as you're starting to tighten up, as you're getting closer to that pre-hearing conference, and we're starting to talk to witnesses, we're getting more information from our client, we're getting medical records, we should be updating these pre-hearing conference statements and amending them and amending them and amending them. And this is, again, just to protect ourselves. This is prophylactic lawyering, okay? This is defensive lawyering, just to make sure that we have something in paper so that we are reserving the rights to at least make the arguments, and then we're reserving the rights for our appeals. Not to jump ahead to the end of my discussion, but like, look, a lot of things happen at pre-hearing conferences. Your proofs might get limited, and then you go through your expedited trial and look at the McGann case. All sorts of kooky things happened in that trial, but they didn't make their objections. They didn't preserve their right to make some of the arguments they should have made on appeal, and that's really bad, right? So that's the thought that I want to share with everyone. If you're not amending your pre-hearing conference statement, like maybe it's because you got no new information ever since the case was referred to us until the time you had the pre-hearing conference. I think that's probably pretty rare. I mean, it could happen, but most cases we should be amending this as we're leading up to it. Now, is there any rule that says we're allowed to amend the pre-hearing conference statement? No, it's completely unaddressed in section 300.38, which is the rule that addresses pre-hearing conference statements. But there's no rule that says we can't, and that's why we do it. Okay, so you can keep amending it, and my argument would be you could keep amending it up and until the date of the pre-hearing conference, maybe even add it if you're getting more information. So let's not fail to do that. So that's accepted and then denied claims. Now let's move on to my favorite kind of claim, occupational exposure claims. And McGann is an occupational exposure claim. So what is an occupational disease? The original statute written in 1911 listed every occupational disease because back then they were like, it's asbestosis, it's silicosis, it's beryllium exposure. They had a list and it was like 25 different diseases that you could actually get from the employment. And then if it wasn't listed, everything was excluded. And then in the 70s, they amended the statute and they just said any and everything can be an occupational disease as long as it arises out of something to do with the employment. So that it's now anything can be an occupational disease. What do we typically see? Hearing loss cases. And by the way, the only kinds of hearing loss cases that can arise under the workers' compensation law can be sensorineural hearing loss, bone conduction loss. That happens just because of old age. It's happening to me. It's probably happened to some of our elders. That's not compensable because that's not amenable. That's not related to any particular employment. That's just your bones shrink as you get older and the bones in your ears shrink and you just can't hear so good. Like that's life, right? So the only kind of hearing loss that's compensable is sensorineural hearing loss. You see a lot of respiratory claims, particularly post-employment respiratory claims. So I've retired and now I think I've developed a breathing condition because of exposure to asbestos or something else. So that could be one of them. And then the orthopedic occupationals, which are the repetitive use or cumulative trauma cases, commonly carpal tunnel syndrome, hint, hint, McGann. All right. What's the statute of limitations in an occupational disease case? I was just talking about this today with Ron, and the statutes in New Jersey and New York are identical. It's 2 years from the date you knew or should have known that you had an occupational disease, which essentially means there is no real statute of limitations in occupational disease cases, because for most of our claimants, it's going to be whenever my attorney told me that I had an occupational disease that was related to the employment. And if you look at the case that we're going to talk about today, McGann, guy works for 32 years, retires, time goes by, and then he brings a case for his occupational exposure claim, right? I also think in the context, retirement claims are pretty typical occupational exposure opportunities for claimants. The other thing you should think about is plant closures. Anytime we're laying off a lot of employees, reduction in force, a RIF, and everybody files their occupational exposure claim, those are when you're generally going to see them. So what kind of conditions should be compensable? Statute's very specific. To be compensable, there has to be something specific and distinct and unique to the employment that gives rise to the condition, right? Sunburns. Every and any employment could expose you to the sun. So like that could never be a compensable condition. Any kind of condition that's like, oh, I had to walk around a lot or stand or sit. It's not specific to any one employment. So you get those occupational exposure claims. It's basically like, my shoulders and hips are bad because I had to walk around for 30 years doing my job. That can't possibly be compensable because any and every, it's not distinct or unique to any employment. The risk has to be not shared with the general population. Great experience or great example, used to represent a photo finishing plant. Everybody who worked in that plant got a very specific type of bladder cancer because they're all exposed to a very specific type of photo finishing chemical. And if you work there for more than 5 or 6 years, everyone developed bladder cancer. Well, it was pretty easy to say, well, that's an obvious occupationally induced injury because you're not going to be exposed to the specific chemical reagent anywhere else, right? So that was pretty obvious. And again, it has to be brought timely, but as I've told you already, the statute of limitations is really hard to prevail upon. Things that are not likely to be found compensable. Nothing specific to the employment. Again, bending, lifting, standing, walking, going up and down stairs, extremes of heat and cold, sunlight exposure. None of that stuff could ever possibly lead to an occupational compensable condition. Could be an occupation, but it's not specific to any employment. And again, those that are not brought timely. The times that you're going to prevail, by the way, in a notice defense in an occupational exposure case is the kinds of cases where you go back in the person's medical records and you go back 10 years and they already had complaints of, oh, I had carpal tunnel complaints 10 years before they brought the claim, right? So you can go back through those records and find a manifestation of the condition, and then you can use that to make the argument, well, they're out of time. Sorry, didn't bring it timely. How do we defend these cases? My advice is the law's not on your side. The presumptions don't help you. The case law is quite expansive. Look at the facts of your case. Spend most of your time on the facts. This is where our paraprofessionals are going to be our best friend, and they're going to like find these golden pieces of information that we're going to be able to use in our case. So I think, you know, look at the work circumstances, find out what we can find out from the employer, work with the employer, what does the work look like, anything we can get. The documents, the witnesses that the employer provides us with are going to be the key to defending an occupational exposure case. This is where we should spend all of our time, blood, and treasure. Don't be writing briefs. Don't be the plate. It doesn't matter what IME doctor you get. The place to spend your time and effort is on building up the factual challenge to how did this condition actually relate to this specific employment. Look at environmental testing. OSHA keeps records of the conditions inside of a lot of these employments. You're going to look for any OSHA complaints that have ever been filed. Some of our facilities, they're issuing personal protective devices. They're giving them hearing protection and all sorts of things. So look into that. Is there a log for that stuff? Again, spend your time looking through the medical records. That's where we're going to find our alternate causation, or perhaps the manifestation that predates our alleged period of exposure. So those are how you win these cases. Look at the dates. That's going to provide your strongest defense. All right, occupational exposure cases should never be on the rocket docket, right? They should never be on expedited calendar. The expedited calendar is not appropriate for any cases that have any type of complex causation issues. So if you're defending my bladder cancer cases, those never belong on a 60-day calendar, right? Because we're going to need to get toxicologists. We're going to need to get cancer experts. There's a lot of legwork that has to take place. Get it off that calendar as quickly as you can and start thinking about, do I have apportionment to prior periods of potential exposure? All right. What can we do? What can employers do? What can the carriers do to help us get better outcomes? And we should be thinking about defending these cases early. We want to sustain their denial. We can control a lot of stuff before the loss, communication, like record keeping. Does the client have good reporting procedures in place? Are they keeping good records? Like, that's going to help us defend these cases. Some of our clients are really savvy, particularly our construction clients, about figuring out where we're going to send people for immediate care, making sure that those urgent care or immediate care records are pretty comprehensive. So it helps us define what exactly happened, what body parts are involved, explaining to the employer, like, this is a kind of a corporate-y way of saying training and understanding how process works at the business unit level, like explaining to the actual employer, like, hey, your participation in this case is going to help us defend it, and this is going to help your bottom line. At the end of the year when it's bonus time and nobody's getting a bonus because they spent all their money defending workers' comp cases and because of over losses, explain to the business, like, hey, if you actively participate, this helps us. There's also an area where, by the way, conflict checks as your cases are developing is important. So you've got a denied case. You're a paraprofessional. You're contacting witnesses at the employer. The employer is giving you witness names. Run those names by intake so we can do a second conflict check. Let's make sure that the witness that we're relying on in our workers' compensation defense case doesn't themselves also have a workers' comp claim against the same employer. Like, is that going to be a helpful witness for us if they're also suing the same employer for something similar or related? Like, probably not. Okay, so best practice, if you're getting witnesses to defend your case, there should be conflict checks done. And don't do them yourselves. That's something for intake to do. That's not something that we should be doing at our desks. I always tell clients about cooperation and coordination. Like, please help us out. These cases are on a short timeline. We don't have a lot of time to develop our proofs or figure out how we're going to defend them. Like, we need some information from them. What's going on? What's happening at the job? What kind of video do they have? Has everyone in this room had the experience where after we've lost, the client then comes forward and goes, oh, loss prevention had a video of the entire accident. You're like, well, that would have been good like 90 days ago. That would have been super useful. Or even worse, when they tell you, oh, we did have video of the accident, but we erased it because we erase it every 2 weeks. Like, that's not helpful, right? So that coordination between us and our clients, that's super important. Our best clients, the most effective ones, are doing rehearsals. Like, they have a clear chain of command. You know who the stakeholders are. Communication is relatively straightforward. Who's going to give us what are they responsible for? I always say also, in particularly denied case context, like, any information we can get from the location, particularly about the person's activities, pickleball, for example, that's useful to know. That's going to help us defend the case down the road. All right. I'm going to keep beating this drum because I think I've brought it up many, many times. record reviews versus IMEs. Record reviews do not have the same stringent requirements. They do not fall under Section 137. So if we need to get some opinions together, consider record reviews. Also consider doing what I've done in cases. I had a case where the issue was complex causation issue. And I knew I had a pulmonary expert. The claimant did not have a pulmonary expert. They had a treating physician. And I just knew the judge was likely going to either say, you have to get an impartial, or I'm going to pick someone off the impartial list. In that case, I went and asked the client to retain every single physician on the impartial list so that the judge could, so they'd all be conflicted out, right? It's a pretty aggressive move. That's also the case, by the way, that I sent Alicia White to the basement of the Ringling Brothers and Barnum and Bailey Circus at Nassau Coliseum to dig out all sorts of information. But being really thoughtful about using record reviews, maybe to disqualify or preclude the other side's experts, like that's something that we could do in particularly the high exposure cases. In my cases, those were all asbestosis cases. All right, prior claims history. We all know about ISO reports. We should be looking into that. Our adversaries do not have the advantage of ISO reports. They're not spending the money to go and look and see how many prior claims their claimant has. This is like an opportunity for you to do something that they're not going to do it. Another thing I like, I don't know if anyone here else likes this as much as I do, functional capacity evaluations, particularly in like the questionable high classification cases. Be thoughtful about utilization of these. I like them because we don't have to pay for the adversary to get a contradictory one, and they rarely do, nor have I ever seen them effectively cross-examine one of a biomedical experts. So that's also an opportunity that we should be exploring. All right, so 30 minutes of background. Now let's get into my case, McGann. And again, I'm looking around this room. I still see some attentiveness, which is pleasant. Thank you. But please help me out here. This case got under my skin. Like, you know, if I'm posting this in the attorney channel, like I'm looking at this like, and no one read it, but I liked this case. This one makes me kind of sick to my stomach. So let's talk about do's and don'ts, because this is everything not to do when you're defending a workers' compensation case. Not to do. And if you only learned a couple things or one thing today, like sometimes when you're reading case law, just, you know, you should read that and you say to yourself, like, imagine if I was in the same situation, what would I do? Or how could I have done this better? Like, this is the case for that. This is, or one of them. There's many of them, right? Some of them are ours, but there's many of them out there. All right, so here's the case. I'll give my summation of it, my summary. Frank McGann is a senior meter reader with the Suffolk County Water Authority for 32 years who retires in May of 2021. All right, anyone seeing any red flags right off the bat? Right off the bat. Anybody? Okay, he's retired. That's a great one. Think about the client type too, because when I look at this case and I look how this is like such a fall down case and nobody really worked very hard and did anything, I'm like, maybe the water authority just doesn't care. You know what I mean? Like maybe they're a government entity and they're just kind of like, well, fraud and abuse is part of my job. I just give money away to these goofballs. Go ahead.
Probably been there for 13 years. Probably got a lot of people there. They're like,
Yeah, he's enmeshed.
take care.
Yeah, they're taking care of their guy.
Taking care of Frank. Yeah.
Yeah, taking care of Frank. Yeah. So I'm just like right off the bat, I'm just like, I always think of, you know, is this an aggressive client or an aggressive employer who's concerned about their employees taking advantage of them? Maybe not. Okay. Maybe they're also used to post-retirement claims. Like maybe this is the culture there. And I've had clients, and we've all had clients that I had one client, major trucking company, one of the biggest trucking companies in America. And they just knew that, you know, and their truckers worked for them for 25 or 30 years and retired with these wonderful pensions and they're part of the Teamsters Union. God bless them. But they knew these gentlemen would work for 25 or 30 years and then they would retire. And a year later, they would file their occupational hearing case, their occupational breathing case, and then their cumulative trauma case for the whole body, right? Everyone did it. And the company kind of got in this position where it's like, okay, everyone knows you're going to get 10 grand for your hearing case. You're going to get 10 grand for your occupational respiratory case. You're going to get 10 grand for your ortho case. And it just became part of like their corporate culture. Like this is the thing that we know is going to happen to us. And we just sort of accept it. So maybe that's going through my head when I'm looking at this. All right. So he retires. Then he says, well, after he's retired, he brings a workers' comp case and he says, well, actually, when I was working there the last couple of years, I began to suffer intermittent tingling and pain in my hands. and these symptoms worsened. And 7 months after he retired, he's diagnosed with bilateral carpal tunnel syndrome, and he believes it then to be an occupational disease. Why? Probably because his friendly attorney at law who advertises on bus stop benches told him it was, right? Or maybe another member or union member or pal from work says, hey, I got money for this, you should do it too. He then files his workers' compensation claim, and the employer denied the claim, right? So, all right, so we're all together on the background. Deny the case, so it goes for a pre-hearing conference. Ultimately, the case gets tried. Now, he had a treating physician named Dr. Harold Avella, who opines. Okay, I heard a guffaw. Opines that the carpal tunnel syndrome was causally related to his job duties. Do you know Dr. Avella? Is he like a frequent flyer? I don't recognize him.
He does claim.
He does claim in IMEs. Okay, so he's a professional plaintiff's doctor. Got it. Now, I didn't know Dr. Stephen Goodman, but then I went into our system, I did a doc search, and I found that in 2022 and 2023, our clients were using Stephen Goodman as an IME doctor. I looked through his opinions. I found 5 or 6 or 7 of them. Does anybody recall having him as an IME doctor? In case a few of you do, okay. They seem like fine to me, couple-page reports, nothing special, nothing bad. His report denies causation. Okay, good. Then he gets additional medical records, including EMG results, and re-examines the claimant. He then reverses his stance, writes a new IME report, and says this is causally related. All right, so now our denial is not looking so good. Treating doctor obviously relates it. The IME physician is now causally relating it. Like, our defense is not looking so hot. All right, there's a trial. Now, here's where the stuff starts to get a little weird, and there's some red flags that should be just popping off for you, I'm hoping. All right, so at the trial, McGann testifies and his manager testify. And basically, it seems like they agree on what his daily routine is. So for 6.5, he works a 6.5-hour shift. And during that 6.5-hour shift, he does keyboard data entry. He sometimes travels to customers' homes, and he uses repetitively hand tools like meter opening and closing devices and valve keys that require gripping, twisting, and squeezing. All right, so that comes out. No one refutes it. But in his direct testimony, he also testifies that, yes, I am an avid pickleball player. I've been playing pickleball since my retirement, and I'm enjoying pickleball. And he admits that that all happened before he filed the comp claims and before he saw these physicians. Now, red flag number 2, we're like, what? The treating physician nor the IME physician testifies. Ugh, all right. Maybe someone said, like, our IME kind of agrees with theirs, so let's not. But now this guy's admitted to playing this pickleball that he did not reveal to either physician. It seems to involve your hands, right? I mean, I know it's kind of like ping pong, essentially. To me, that's weird that they didn't have the treating physician or the IME physician testify. It turns out that he's an avid player. He's been playing regularly before he filed his occupational injury claim. It's also true that he did not tell the treating physician nor the IME physician he's a pickleballer. And after his testimony is complete, the employer raises fraud. And they say, look, you concealed your actual abilities, your recreational abilities. Obviously, your activities of daily living have been concealed. And they said, hey, you didn't tell us about this post-retirement, but again, pre-seeing the doctor's hobby. Okay, so we're all together there. Again, I think fraud is properly raised in this case. The judge at this point then says, this is the trial level judge, says, all right, guys, I don't know, go get addendum reports from your treating physician and from the IME physician. Okay, addendum reports. And I want you to have the treating physician and the IME physician incorporate the hearing testimony and give me new reports, taking into account the fact that he now admits he's been playing pickleball. Okay, and here's where it gets a little wonky. And we don't know how they did this or how it was done because it's not in the record, but both physicians complied. They both issue addendum reports, and they both continue to find causation. All right, so if we didn't have Stephen L. Goodman off our list of IME doctors in the past, take him off now. Okay, no. We presume that the treating physician, and now that I know that Avella is a frequent flyer, would do that, but I'm kind of surprised that the IME physician or the defense medical expert still affirmed causation. Now, I don't know, do we think they wrote a really good cover letter to the defense doctor? I suspect not, right? I don't know what was sent to him, but I mean, I would have written a very one-sided, lopsided letter saying, hey, this is what he's testified. And by the way, did you know that he concealed his actual recreational activities from you? And by the way, couldn't these activities by themselves cause these conditions and tingling and pain? And don't you think it's interesting that he chose to hide this? I mean, I think I would have pointed all of those things out to the IME physician. So they come back, got these addendum reports. They don't really help anybody. Now, red flag number 2. What did the defense counsel fail to do once again? I want to cross both doctors. Like, this is insane to just go put the reports in. I don't get it. The trial judge then upholds the claim for occupational disease. It says, I don't see fraud here. He concealed his post-employment activity, but I don't think it's colorable. It's not fraud. He can win. Employers loses. And he's got his bilateral carpal tunnel syndrome cases established. All right. Attorneys, paraprofessionals, what is bilateral carpal tunnel syndrome worth? How would you compensate that? What do you say? 15 and 15. Okay, I agree strongly. So it's 36.4 weeks. So it's like 72.8 weeks of compensation. The back of the envelope math, it's like just under 50 grand, right? And it's a slew too, right? Because if you're him, you want to slew these both, even though you got 2 body parts. I'm going to slew them both because you don't have to show attachment. You don't have to show, and this is a post-retirement case. Okay, so, he wins. The employer appeals. So this should have said employer appeals to board panel, sorry. On appeal, the Workers' Compensation Board reverses the trial judge's finding. Yay, the good guys win sometimes. The board rules in favor of the employer and says Avella and Goodman's opinions are unsupported because the claimant's history is incomplete, inconsistent, and not credible, and he failed to inform the physicians of his pickleball playing. The claimant doesn't like that because he's got his win reversed, and he goes to the full board and says, I want a full board. And they said, no, we're not going to reconsider this. Sorry, you lose. He then takes his appeal to the appellate division. Here's where it gets even worse. I don't understand how these became the issues on the appellate division and how the defense brief didn't bring this up. But the 2 issues that were addressed by the appellate division is 1, the treating and the IME doctor found bilateral carpal tunnel claims, were causally related to work. And the trial judge found the carpal tunnel syndrome compensable, but the board panel rejected this finding in light of the recreational activity and concealment and reversed the trial court. Okay, that's the good guys winning. The issue on appeal was authority over medical testimony. May the board reject uncontroverted expert opinions and by doing so, effectively use common sense to forge its own medical determination. Okay, so again, the 2 medical experts don't disagree, but anyone with half a brain, right, with an IQ above room temperature, realizes that this claim has got some real problems, right? So that's issue 1. Issue 2. What's the relevance of the recreational disclosure? Does omission of post-retirement pickleball activity negate the causal link by itself between the work duties and carpal tunnel syndrome, even where the physicians know about it, right, and issued these addendum reports? Okay, so this is problematic in from my perspective. And again, we don't have the briefs that were written, but I think that there's strong arguments in favor of the employer and the defense here. The appellate court comes back and says, now the board cannot just overrule or ignore uncontroverted medical opinions and substitute it with its own medical opinion. Okay, again, anybody with brain function knows that this is a ginned up claim, but they say can't do it. The board panel's decision to give no weight to the addendums, which expressly integrated his testimony, rendered his decision unsupported by substantial evidence. Remember, the word substantial evidence means any evidence, but there is evidence, right? It's his testimony in the case. The board's ruling is reversed and it's remitted for further proceedings, essentially to give him an award for slews for both hands. Huh? What? So this case gets under my skin, and essentially his carpal tunnel claims are now compensable. Employer's liable for medical treatment and slew. Moving forward, this is the part where you all boo. Boo. All right. Boo. All right. So that's our ruling. So What went wrong? Who wants to talk with me in front of the group about what went wrong in this case? Now, we've talked about a couple of things that went wrong in this case. Who wants to share? Yay. Okay. Behind you, directly behind you. And can people think of other things that we haven't talked about or thought of yet that have gone terrifically wrong here that would never happen to us, ever? Go ahead.
Well, for occupational claims that are like so old, like, I mean, the gap between work and the claim, I wouldn't even get an IME or a record review because most likely causal relationship is going to be conceded. There's no question that he has carpal tunnel. It's just
But
how
did he
did it
get-
happen?
All right, can you explore that a little bit? You would have skipped the IME.
Yeah, I mean, we know that we're not asking for a diagnosis. We know the diagnosis. I think the facts, not the objective evidence, are more favorable in this situation, especially occupational claims where like it's more of a like subjective reporting by a claimant. And then all of a sudden he has this medical report that says, oh, I have carpal tunnel.
And related.
Yeah.
All right, so you'd skip the IME. All right, in the back, I see a hand raised.
2 years. This guy, there's got to be some type of medical evidence in his file that shows something else has something to his hands. I would assume that there would be at least. So probably a deep dive into those prior medical records, get everything that you possibly could. I know you might not be able to get everything, given the fact that, we're talking 32 years, probably maybe you get 10 if you're lucky, but
Okay, so here's a crazy, this is a little minor point, but it's in the decision. There was no discussion about prior medical history. It was completely silent, right? But yeah, I would dive into that. But there is a statement in the appellate decision that he did have a prior shoulder and one other body part claim. And when they looked at the medical records in those claims, there were never any hand complaints. Okay, so that I think is useful. Go ahead.
Two things. Why aren't we getting the social media earlier? Like on an OD claim, we should get that right away. We want to know.
You ready for this? I don't think they had, I think the guy just testified, honestly. Someone said to him, well, what are you doing? Do you do anything now? And he goes, oh, I play pickleball every day. Woo! There was no mentioning here of any covert surveillance or social media. I think the guy just blurted it out during his own testimony. You're nodding, right? Because that's how you read the case as well, right? It doesn't look like they had developed that fact on their own at all.
The other part of it is I would have appealed the direction for addendum. Law judges only do that because they want to get out of giving a fraud finding. When they're saying go get an addendum, they're looking for a reason not to make a fraud finding or to establish a claim because they want the doctors to both agree. Yeah, we have all this information. And the information you're giving them is job duties, right? Which doctors probably didn't know about before. And now you're telling them this is exactly what the claimant did. And
Good. All right. We have 1, 2, 3, 4. Hold on. 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. Yep. We have 17 attorneys sitting in this room right now. Show of hands. Show of hands. And the clients can't see you. They can only see me. So they're not going to know what you answered, but I'll know. Okay. Show of hands. I'm sorry. 18 attorneys. Sorry, I didn't see you back there. You were hidden behind Dan. All right. Show of hands in this room. Can a law judge order you to get an addendum? All right. Okay. Thank you, Mr. Lawyer. Would you throw him the thing? Can you throw? Okay. So what did you say, Mr. Lawyer? I said, can a judge order you to do it? And you said, Mr. Lawyer, go ahead.
I mean, they can direct you to get it, but
They can direct you to get it. Yes, they can. And they do all the
or
time.
it.
All right. I should have formed this question a little more carefully. Is there any legal authority that gives the law judge the opportunity to command or instruct or require us to get an addendum report? Okay, so show of hands. Who thinks they can do it? Who thinks they can't do it? Okay, so there's a lot of hands going up, and Lauren's hand in the back is very high. All right. So interestingly, I couldn't find any precedent one way or the other. I think that it's entirely silent about whether they can do it. But the there is case law that says the judge may request clarifying medical, right? So there is case law that says they can do that in order to fully have all the information necessary to decide a case. But I haven't find any case law that says clarifying medical means they can make you, defense, employer, go get another IME because they didn't like what your first IME said. Because I've never found any authority for that. So the answer is, I don't think the precedent, there's any way you can point one way or the other. I know that they've done it to me. And by the way, I've been situations where I'm like, thank goodness the judge said that. I would love to get another bite at this apple. Like, sure, right? But I couldn't find any authority that stands for the proposition that they can require you, because that gets into the slippery slope of, well, why aren't they just picking our IME doctors? If they can reject us or tell the doctor to rewrite their opinion or change things, right? I mean, that's problematic. I mean, that's a due process violation at the very least there, if they're picking your experts for you. So I don't know. I think it'd be a fun law review article. Can the judge require an addendum? I would tell you that someone said, I would have said no. Ron, you're a New Jersey attorney. I can't call on you. All right, throw him the cue. Oh, here we go.
So after the reports are submitted, and then supplemental reports are requested, could the employer's attorney at that point have asked for live testimony from the experts?
Yes.
And they did.
They chose not to for some reason. I don't understand it.
In New York, can they secure, I'll call it the court, can they secure their own exam?
Yes, the judge can call an impartial.
Okay.
Right. Which, by the way, if they have that opportunity, why don't they do that? But this wasn't even a tiebreaker. This was, I think the judge was looking at this going, well, this testimony came in the way nobody expected it to, and let's do a start over and maybe get my job done for him. All right, someone throw Mr. Melchione that cube. There he goes.
I think that fact also underscores the mystery as to why a development of the medical record wasn't directed or requested. I think that more likely than not, I don't think I can think of many cases where I was directed ever. In my case, where the carrier was directed to get an addendum, I think that in 9.5 times out of 10, they would say, I'm directing the deposition of the doctors on the issue of whether their opinion on causal relationship would be modified or changed if they knew this fact, which would have given us, or a person standing in our shoes defending the employer, the opportunity to say, did you know this? Would this change your opinion? Don't you think that the mechanism of playing pickleball kind of mimics the same type of mechanism that's alleged in this claim? So it's still a mystery why no one requested cross, or why the judge didn't simply say, go depose the doctors and ask them for their opinion.
Exactly. Right.
A little weird.
Way better position to be in. Go ahead. All right.
Framed it at the cross-examination of those doctors. Listen, not even a causal relationship issue necessarily. It's a 114A issue. No other doctors knew about this.
Right.
And that's how you get cross. Even
I don't think
no
okay, so that's a great point. So the point is, you've raised 114A, and maybe you're going to ask about the issue of concealment to flesh that out, and that's how you can get the doctors to testify. I don't think you even have to do that.
No.
Like, it's a great idea, because Lazarus says you don't have to.
Right, and then the court, the appellate division couldn't rely on the precedent by saying uncontroverted medical evidence can't be impugned, because then through the development of the record, we could have impugned the credibility of the doctors, and then the judge could have said, well, now I find them both not credible, and I'm going to maintain the reversal of the decision.
Excellent. I agree strongly. I would also tell you the case law is Lazarus. It's a 2022 Court of Appeals decision, Lazarus versus Wegmans. We've all heard of this case that says the employer has an absolute right to depose any physician they want, anytime they want. And it's also in the regulation. 300.10 specifically says that we shall be granted the right to cross-examine any witness against us. Now, you had something to add.
Yeah. I know we discussed, maybe the employer is generous to people, but I didn't get any sense of what the employer's perspective on the job duties were. Maybe you only turn valves once a year in an emergency. And the first thing we would want to do is personnel file, talk to someone, like when we open a lit plan, what were his duties? And I don't even think they presented that.
Well, someone from the employer did testify. Some manager did verify, here's the things he did. But you're right. How often? Were there any ergonomic studies done? All those types of things. All right, go ahead.
Just quickly, I mean, we're in the ANCR trial. He now testifies to this new thing that we just discovered. I mean, at this time, wouldn't you just make an application to disallow the claim on causal relationship basis? Because you're going to argue that the medical reports are in the file. Yes, the doctors found causal relationship. However, they don't know this. So let's just get rid of it. Like,
Agreed. I
Oh.
mean, that's kind of what the board panel did. The board panel's like, okay, we're not idiots. We're throwing this case out, right? I mean, that's the board panel used common sense. The appellate division did not. Yes, sir.
I know you mentioned that employer witness testified, but one thing I always like to know for a lot of these OT claims is, it says he retired. Why? I mean, what happened? What kind of employee was he? Was he good, middle of the road, not so great?
2 years. I'm sure he
Right.
retired with a nice pension.
That's what I mean. Like, what kind of, like, I mean, we have certain employers that they may be there for 30 years just because, but that doesn't mean they were good employees.
Mm.
I always want to know, how were they, what happened? And then another thing he said 2 years ago, did anything happen 2 years ago? Did he get a demotion of any kind? I'm just kind of wondering, I always wonder.
What motivates him?
Exactly, the retaliatory, I mean, his credibility is concerned, retaliatory and imaginary.
Yeah, it's interesting. I suspect that this is like I retired and now I'm going to file my claims. I'm not there anymore.
Gold
Let's-
watch scenario.
Gold watch scenario. That's kind of my take on it. All right, we're running out of time here. This is good. Thank God you guys spoke. I appreciate you all, every single one of you. So I think there's at least 3 mistakes. I think we've covered all of them. Mistake 1, not requiring testimony is like, that's a huge blunder, hugely problematic. Would have look, if they had taken the testimony of the doctors, good, bad, or indifferent, then at least the board panel's decision could have incorporated that. And then the appellate division couldn't say there's no substantial evidence refuting the positions of the 2 physicians, which was really what they stood on for deciding not to overturn this case. Section 10 is the section that says you always are allowed to take the deposition of the treating physician. Never, ever, that you cannot be bluffed away from doing that, even if they threaten you with a frivolous controversy. And I imagine they did in this case, right? I imagine the defense counsel sitting there and they're like, the judge is like, well, your doctor agrees with their doctor, so why do you want to take their deposition? You're being frivolous. And I'd say, well, because, rule number 10 of our rules and regulations say I can. I think, and then you could point to the Supreme Court case of Lasley, which is a 2023, sorry, not 2022 decision. Mistake 2, I think they should have raised the objection at the trial level. It was not raised because they didn't preserve it for appeal and was not appealed. Once you ordered us to get an addendum, you've kind of destroyed the surprise value of what that information I had, that he had this post pickleball activity. It just gives the claimant a chance to fix it, right? They can rehabilitate that. I think everyone's kind of tied into that. While a judge can direct clarifying medical, how is it clarifying to get a new medical opinion? It isn't. These are just new facts. You're getting a new opinion. I think we should always be challenging those. I also think the employer should have said, well, this is also fraud because it's concealment. And that should have been part of their defense brief on the appeal. I think it's ridiculous to say I got hand and wrist injuries, I'm disabled, but by the way, I'm able to pursue active pickleball career. So those things I think are really challenging. But again, approaching the subject, cases come in, admitted or denied. The denied ones, guys, this is on us to do the homework and to defend them fully, put these cases in the right way. And even if you lost at the trial level, like this defense counsel did, if they had done a little bit better job of getting those proofs in there, then they would have won at the board panel level, and that would have gotten sustained, I think, at the appellate division level as well. And this would have been a win, not a reversal and loss. So some takeaways, let's be decisive. Our job as defense counsel is to get these denials sustained, research, investigate, present all defenses. You can win them. You can always withdraw a denial. So if we over deny, that's okay because you can withdraw it. And these occupationals can absolutely be defended. My advice, look to the facts, develop the proofs, do the homework. This was a winnable case. It was made unwinnable by, I think, defense counsel behavior at the trial level. So that's it. Other ways to learn, email newsletter, check out my partner's podcast. There's something I have to look at in the chat. Sorry. Here, I'll just put this one up there. Okay. Stop sharing. 85 people. Chats. Chat. Oh boy. Okay. Okay, Suzanne says, what about an injury? Then they continue out with arthritis issues. Was this applicable as well during COVID? All right, what? What about an injury? Then they continue out with arthritis issues. I don't know. Clarify that. I need clarifying chat commentary. Was this applicable as well during COVID? Yes, all the presumptions. Is that what we're talking about with it? Oh, that was our anti-COVID argument, that if this is truly a pandemic, which means by its term that it's everywhere, that it can't possibly be an occupational compensable disease, right? And then the board came up with their new standard, the made-up standard, if it's prevalence in the workplace. Interestingly, did everyone see the appellate decision that came out about 2 weeks ago, where a custodian who worked in a school system where there was COVID all over the place, brought a COVID claim, and it went all the way up to the appellate division, and they said, well, you can't really say it was more prevalent there than anywhere else, and they denied his COVID claim. So now they're seeming to apply the standard kind of the opposite. So again, but I don't think we've seen a COVID case here in quite some time. So probably not such a big problem. But yes, they created their own standard for COVID cases. I would venture to guess that the award that the claimant received may have been less than what the employer paid in legal fees. Carpal tunnels aren't that expensive. This shouldn't have been appealed. What? Remember, they made the appeal to the board panel and won, and board panel appeals are quite efficient, right? You're not paying the award because the award is stayed. It doesn't cost much to appeal to the board panel. There's no filing fees or anything, and it's just a couple hours of attorney time. And by the way, they did win, so it actually, I think, was a good use of time and resources. That's my opinion. By denial, wouldn't that help slow the rash of claims? Yes, right? Sometimes you're defending these cases and being an advocate and being aggressive because it's got some social proof that we're going to see in this workplace. You know, if you're the Suffolk County Water and Light Department or whatever the employer was, maybe you challenge a couple of these cases and by the way, you show somebody's a fraud like this guy is, and then the message comes out to your employees, right? So that's the social proof that hopefully we're trying to develop. Oh, and Connor says, I want improved intentional self-harm under Section 10 in this case, Luciano Ramos. Okay, that's amazing. Very good. Thank you. Can you please share the QR code for the evaluation again? Oh, are you going to give me a good evaluation, Ilya, or a bad one? If you say good, then I will share it. Knee injury then later develops arthritis, which may or may not have been there prior. We get stuck with the prolonged claim. All right, so welcome to workers' compensation law. Unfortunately, I have to tell you, in New York, these cases never get any better as they develop and they bring in more and more body parts, right? Like it just gets worse and worse. Then our job is to stop that, right? We know the frustration that our clients feel. Okay, it is like 5:03. Thank you for hanging in there. Go fill out your professional development trackers. And thank you very much for your participation today. Made it so much more fun for me. All right, thank you at-home players.